Hello viewers, Namaste. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. Today is the first lecture of those series. In today's lecture, we will try to understand what are criminal laws. Why do we need criminal laws? Who defines what constitutes a crime? And what are the different types of criminal laws? What are the criminal laws in existence in India? So, to begin with, what are criminal laws? Laws that deal with criminal behavior. It is often said that crime is the creation of the state. Now, does that mean that the state creates crimes? The answer is no. What it implies is that the state defines what is crime. It is often said that crime is defined in the light of dominant ideology of the state. See, why this happens is because society changes, human behavior also changes with time, and as people resort to different kinds of behaviors over the times, the law has to keep pace with the changing needs and demands of the society. So, laws, they cannot be static. What any society needs is stability, but we cannot allow our laws to become stagnant. And as we all know, change is the only constant. So, what was required is that laws, they need to keep evolving in order to counter the new kinds of crimes that develop over the time in any state. So, crimes are prosecuted always by the state. Crimes are treated as public wrongs. See, even though the victim is an individual, but crime is a behavior which has been forbidden by the state, and that is why when somebody commits a crime, when anybody does something which they have been expressly forbidden by the law to do, or when they don't do something which the law enjoins them to do, then that constitutes a crime for which prosecution is initiated by the state. So, crime, what constitutes criminal behavior? The state defines it categorically, and as I said, the definition of crime keeps on changing. See, there was a time when the practice of dowry was considered as a very good practice. There was a time when when women, they would burn on the pyres of their husband, and there was nothing objectionable in it. But then we realized that there were certain practices which were violative of the human rights of a category of human beings, that is women, and it was realized that it was a time to outlaw those practices. Therefore, we enacted the Dowry Prohibition Act, the Sati Pratha Prohibition Act. Similarly, when we talk about crimes such as adultery, homosexuality, these were crimes which were earlier accepted in the law, but now they have been effaced from the statute books. Similarly, there were certain crimes like when we talk about the crime of theft. Earlier, theft could take place only in respect of tangible movable property. But over the times, it was realized that we had crimes of data theft. So, what has been done? The definition of movable property has been now expanded to cover even intangible movable property. So, you see, this is how the law keeps on evolving. So, today in the first lecture of this series on new criminal laws, we will try to understand these new criminal laws. So, first of all, let us understand what are the various types of criminal laws. So, mainly criminal laws are of two types. One is the substantive law and the other one is the procedural law. So, what is the substantive law? Any law which lays down the substance of a crime, that is a law which defines what are the essential ingredients to constitute a crime. So, a criminal law which lays down the essentials to constitute criminal liability, and at the same time which also lays down the conditions that entitle a person for exemption from criminal liability are known as substantive laws. In India, as of date, the substantive law on crimes is Indian Penal Code. Now, Indian Penal Code 1860 is the substantive law, and the procedural law on crimes is the Criminal Procedure Code of 1973. So, what is the procedural law? See, once we have a substantive law in place which defines what is acceptable conduct, what is unacceptable conduct, then we need a procedural law to try those people who have conducted violations of the law. So, the procedural law defines how a person is to be arrested, it lays down the procedure, how they are to be apprehended, how crimes are to be investigated into, how the accused persons they are to be tried by courts, which would be the appropriate forum to try the crime of the particular magnitude which a person has been accused of. While undergoing trial, we have to ensure that the rights of the accused persons are not violated, whether a person has a right to be released on bail, whether the accused has the option to go in for plea bargaining and settle for a lesser charge or a lesser sentence, then how the sentence is to be pronounced, what is the punishment that is to be awarded and how that is to be done, all that is laid down in detail in the procedural law. See, unlike other laws, when we talk about criminal laws, there has to be an absolute certainty. Why? Because criminal laws, they are always prospective in operation. So, as of date, a person can be clear about what the person can do and what the person cannot do if only it is spelled clearly in the laws. So, criminal laws have to define exactly, categorically, in clear terms what constitutes criminal behavior, and that is why we have a very meticulously drafted code and which runs into 511 sections. But see, that was a code which sustained us for so long, but with time now we need to change. From 1860 to 2023, it has been a long time. So now what was required was to bring in a change in a substantive law. At the same time, if the substantive law changes, we also need to change the other procedural laws. Substantive law being the main law, unless and until there is a procedure which tells how those transgressions of the prescribed law are to be penalized or how those people they are to be apprehended and tried. If we don't have the supporting laws in the form of procedural laws and evidence laws, those substantive laws would be meaningless. So that is why now when we have overhauled and brought in new substantive criminal law, at the same time we needed to overhaul our procedural law, and in addition to this IPC in CRPC, there is another law in existence which is law relating to evidence, which is the Indian Evidence Act. And law relating to evidence is the codified law that lays down rules of taking evidence in civil as well as criminal cases. So, while we are talking about the substantive and procedural law related to crimes, it is important to understand here that evidence law is applicable in both types of cases, but when we talk about the entire bulk of criminal laws in country, the three main laws that we talk about are the substantive law, procedural law and law of evidence. It is only when these three are taken together, studied together, that we understand basically what exactly all the criminal laws are about. So, let us now decode the titles of the three new criminal laws. We all know that a bill was introduced first in August, thereafter we reintroduced the bills in the amended form in December. They were finally enacted by both the houses of parliament, they were voted for, and now we have the new criminal laws. They were enacted in December 2023, the president assented to them, and now the state government has notified. So what are the three new criminal laws? First, is Bharatiya Nyay Sanhita. So viewers, Bharatiya Nyay Sanhita is the law which is going to replace the Indian Penal Code of 1860. So this is the new substantive law related to crimes in India, Bharatiya Nyay Sanhita. Thereafter, Bharatiya Nagarik Suraksha Sanhita 2023. This is the law which will replace the Criminal Procedure Code of 1973. So, Bharatiya Nagarik Suraksha Sanhita is the new procedural law related to crimes in our country. Then, Bharatiya Sakshya Adhiniyam 2023 is the law which has replaced the Indian Evidence Act of 1872. So, the new law related to evidence in our country would be Bharatiya Sakshya Adhiniyam. Taken together, these three new laws, Bharatiya Nyay Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam are the three new criminal laws that everybody is talking about nowadays. Moving on, now let us trace the evolution of these laws, or what is the historical background of criminal legislation in our country. See, earlier the criminal laws, they were not codified. Okay. The first Indian Law Commission that was set up in 1834, they gave certain recommendations. Then we had this Lex Loci report in 1840 which recommended that yes, we need to codify the various laws, whether it is criminal laws, whether it is civil laws, so except personal laws. So what are personal laws? Personal laws are those which regulate people in matters, personal matters such as marriage, divorce, succession, inheritance, maintenance, guardianship, adoption. So they said that these should be governed by their own religious laws, but for all others, we need to develop secular codified laws, whether it is the civil domain, whether it is the criminal domain. So, accordingly, the second law commission was set up and we got the Indian Penal Code, which was the first substantive law on crimes in India in the year 1860. It was drafted by Lord Macaulay. That is why it is also known as the Macaulay's Code. Then the moment we got the substantive law, it was realized that we needed a procedural law also for its effective implementation. So the very next year, that is in 1861, we got the Code of Criminal Procedure. But at that time, we had separate procedural codes for provinces and presidential towns. In 1882, we got a unified code. 1898 it was further amended, then it was amended in 1923. Thereafter, when we got our independence, on the basis of 41st report of the 50th Law Commission, CRPC was completely overhauled, and in accordance with the ethos of Indian people, we evolved it and we enacted a new criminal procedure code in 1973. See, why this was important was because Constitution guaranteed us all so many rights. So we have now talking about rights of the not only victims but rights of the accused persons also. See, a person who is accused, till the time a person is not adjudged guilty and convicted by a court of competent jurisdiction, till that time every accused is presumed to be innocent. And even otherwise, the way a person is to be apprehended, tried, this has all to be done in a constitutional manner. And that is why constitutionalization of the procedural law was an absolute must. And that is the reason why we needed to overhaul our criminal procedure code, and that was effectively done by the year 1973. So we had the Indian Penal Code in 1860, then thereafter Indian Evidence Act was also drafted in the 1872. Okay. So we had these three laws which were dealing with law related to crimes in our country. Now let us talk about how the law will change. from the Indian Penal Code, which was drafted in 1860, to Bharatiya Nyaya Sanhita, how is the law going to change? Foremost, earlier the title was Indian Penal Code. So, IPC had defined India as the entire territory of India except the state of Jammu and Kashmir. After the abrogation of Article 370, we need not define it anymore because we know the entire territory of India is our Bharat. So, the term India, it has been replaced by Bharat. From Penal Code to Nyaya Sanhita. See, earlier the objective of the substantive law was to penalize. The objective was punishment. And why was the objective for punishment? Because see, we have to understand how the law was enacted and who enacted the law. This was a law which was enacted by the Britishers, who were our colonial masters. So, when they enacted the law, the objective was to control their subjects, to punish those who would transgress the laws which were laid down by them. So, that is why they enacted a code for their subjects, and that is why the objective was implicit in the title when they said Indian Penal Code. The objective was to punish. Now, when we have a law which has been enacted by our state, by our democratically elected leaders for none else but their own people. So, we can expect a shift of orientation from penalty towards justice, and that is what is indicated by the title of the law when it says Bharatiya Nyaya Sanhita. So, now the objective of this law is justice. See, in a criminal justice system, when we talk about how a person is adjudged guilty for a crime, how we punish the criminal, so punishing the criminal does not translate into justice for the victim. Does the victim get anything when we punish the offender? Maybe a little bit of satisfaction that yes, I have been avenged, but then that is it. Does the victim get a comprehensive form of justice, or is retribution the only form of justice? So, that is something which any welfare state has to think about, and that is why we needed to change this old archaic colonial law which was enacted by our imperial rulers way back in 1860. So, from 1860 to 2023, it has been a long time, and we needed to change a law also to address the new challenges that are coming up in the criminal justice system every day. So, one thing was to reform our perspective from punishment to justice. Another thing was, because see, as I said, change is the only constant. Society is evolving and law has to necessarily evolve to keep pace with the changing needs of society, because law is the most potent tool for social transformation. Sometimes there are certain crimes which are continuing unabated, and the law has to step in to put an end to that kind of a criminal behavior. And sometimes when we realize that in the light of changing moralities, there are certain behaviors which can now be overlooked, or maybe they can be dealt with as mere civil offences, they need not any longer be treated as crimes. So, that is also the time when the law has to be decriminalized, those provisions they have to be decriminalized in respect of those particular crimes. So, that is what has happened when we have overhauled the law from IPC to BNS. So, let us talk about certain major changes that have been brought about by the Bharatiya Nyaya Sanhita. Certain crimes have been made gender neutral. See, whenever we talk about sexual assault, it is always seen as a gender specific crime in respect of the substantive criminal law when it comes to adults, because see, although we have POCSO, which is a gender neutral law, But POCSO is applicable only to minors. POCSO is protecting only children below 18 years of age. When we talk about people above 18 years of age, so we still retain the old term which is rape, and rape is a gender specific crime. But in addition to rape, there are so many other sexual crimes also which have been dealt with under the law. So, in the wake of Nirbhaya incident, when Justice Verma committee had recommended certain changes in the criminal law in 2013, and accordingly Criminal Laws Amendment Act of 2013 had introduced certain new categories of crimes. At that time, we had introduced sexual harassment, stalking, voyeurism and disrobing as specific crimes in the Indian Penal Code. Now, at that time, we had kept only the crime of sexual harassment as partially gender neutral. When I talk about partial gender neutrality, what I mean is that when we talk about the crime of sexual harassment under the Indian Penal Code, the victim can be both man as well as a woman. See, the law acknowledges that men can also be subjected to sexual harassment, but what the law says is that the perpetrator of sexual harassment can only be a man. So, anyone can be subjected to sexual harassment. It could be a man who alleges sexual harassment, it could be a woman, but who can be accused of sexual harassment as a crime? Only another man. So, that is why it is only partially gender neutral. It is not totally gender neutral, like see when we talk about POCSO, it is totally gender neutral in the sense that the accused can also be either a man or a woman and the victim can also be either a man or a woman. But when it comes to sexual harassment under the IPC, it is only partially gender neutral. So, that was it. And after that in 2023, what we did, disrobing, of course it can be done by anyone against anyone, but when it comes to stalking and voyeurism, what happened that it was only a man who could be held guilty of stalking or voyeurism. Okay. But now what they have said that a man, it could be anyone who can be guilty of that, but victim of stalking, victim of voyeurism can only be a woman. So, partially we have tried to make these gender neutral. Earlier they were totally gender specific in the sense that only men could be convicted for that and the victim could only be a woman, but now it is a man as well as a woman, anyone can be convicted for that, but who is protected is only a woman. Now, when we talk about certain new crimes that have to be introduced to deal with the changing needs of society. So, that is like I said, with the changing needs of society like technological advancements, see, and then we see there is so much of threat of terror, crime is happening in a more organized manner. So, what we needed to do was to bring in newer categories of crime such as terrorist acts. Now, we have also defined what is organized crime and crimes such as theft, which have been given a broader definition under the law, and so on and so forth. There are many more new kinds of crimes that have been introduced in the law now. Another objective of this is to restructure and reorganize the old code in a very systematic manner. See, IPC was spread over 511 sections. Definitions, explanations, they were also spread over a large number of sections. Now, what have they done? All the definitions, all the general explanations, they've been put in one section. All the exceptions thereafter they begin. Then punishments, they have been compiled in a limited number of sections. Then all the crimes related to women and children, they have been clubbed together in one chapter. So, this is how they have restructured and reorganized. Similarly, when we talk about inchoate or incomplete crimes such as abetment, criminal conspiracy and attempt. So, earlier we had abetment, then we had a chapter on criminal conspiracy, then at the end of the IPC we had one single section dealing with the offence of attempt. Now, all these three have been clubbed together and placed in one single chapter. Then what was required was to remove certain archaic provisions. See, when we talk about the crime of adultery, the way the crime of adultery was defined in the Indian Penal Code, it left much to be desired, because under that, woman was treated as the property of her husband. Her sexuality was the absolute monopoly of the husband, in the sense that if the woman without her husband's consent had an illicit relation with any other man, then the husband had the permission to prosecute that other man. He could not prosecute his wife. Similarly, the wife of that other man, she could prosecute neither her husband nor the woman with whom her husband had been in illicit relation. So, this was such an archaic provision which was violative of Article 14. That is why it had to be struck down. So, students, these were the main points related to the substantive law when we make a shift from Indian Penal Code to Bharatiya Nyaya Sanhita. This will be all for this lecture. See you soon in another lecture in which we will be talking about the main points of Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. Thank you.